Welcome to Protecting Your Legacy with Estate Planning.
Hello, and welcome back to Protecting Your Legacy with Estate Planning with Adam Grant. I'm Chelsea Reynolds. Adam is the founding attorney of Stonewood Law Group, PC, in Encino, California. He helps families across Los Angeles, Orange, Riverside, Ventura build clear, comprehensive plans that protect what matters and avoid probate. Today, we're talking about a step many families forget once their estate plan is signed: keeping it current. We'll look at when and why you should review your plan and how to make sure it still does exactly what you want it to do. Welcome back, Adam.
Thank you again.
Adam, a lot of families think once their estate plan is done, boom, they can forget about it. How do you explain why reviewing it every so often is just as important as creating it in the first place?
Yeah, it's a great question. It's a living, breathing instrument. And again, this is an instrument that you are contractually allowed to make between yourself. This is a constitutional right that we are given to contract with ourselves, and we're allowed to distribute our property to the people we want it going to. So this is where we pick up those pieces and ensure that we're going to build something that's long lasting, that's going to reflect your wishes and also be up to date, so that God forbid if anything happens to you, you have that peace of mind at that point that the pieces are in place. The distributions and the beneficiaries you want getting those distributions are going to accurately get that money. Now, every few years, your family may change. You may have a death in the family. You may have new children or grandchildren. You may have purchased new homes, acquired new businesses, new interests in businesses. Perhaps you've made a business from a corp to an S corp. There are a lot of things that you may want to reevaluate every few years, and that's a great reason to just reach out to your attorney, check in. If the circumstances haven't changed, at least every 5 or so years, 3 to 5 years, just say, have the laws changed significantly that I should look at doing something to my trust? And I think that's where you can just ensure that it's always up to date. It always has the wishes you want in there, and they're going to be reflective of the people you want it going to when that time comes. And you keep it updated. So it's a revocable living trust. Until something happens to the last surviving settler, you're allowed to make changes, change your beneficiaries, trustees, revoke the trust, restate the trust in full. So you have a lot of flexibility to make changes and keep it current. And we just say it's important to keep it current so that, God forbid, if anything happens, you have the right people receiving what you want. And also you have that comfort of understanding your estate is in order, your assets are together, and there's a smooth transition or continuity between the transition after your death when the trustees pick up the pieces.
You touched on a few of these already, but what kinds of life changes usually would cause an update? Things like marriage, divorce, buying
Yeah.
property. What else should people watch for?
Yeah, so big ones are marriage, divorce. Of course, we want to consider things if there's a pre or post snub, but changes in family. If you've had kids or grandkids, that's a big reason to perhaps ensure that they're covered in there. If you adopt a child, if you have significant changes in your life circumstances, you've bought a new home or acquired a new business asset or an interest in that asset. You just want to ensure that the right pieces are together, and perhaps you've come into an inheritance or acquired a large gift from a family member. If you want to put that in the trust and ensure that it's separate property versus community property, you want to just do things correctly. So you can make simple amendments to your trust without having to do a new trust every year. And it's a very easy process. Depending on the attorney, you just reach out, request the changes. You talk about how that works, and the attorney is going to look through the trust again just to make sure nothing else needs to be updated. And then you make a simple change by amendment or restatement, and that's then reflective of your up-to-date current wishes.
Here's a tricky one. How about changes in California law or tax rules? Did those ever make existing plans out of date, even if nothing in the family has changed?
Yes, so both federal and California state law will affect how trusts operate. The Big Beautiful Bill is one example, and we're still learning and trying to digest how that's going to affect our clients. But in the long run, these changes, both on the federal and state level, happen often. So we do say review your trust on a regular basis, because that's where you're going to ensure that these changes in the law are accounted for. And if they do have an impact on perhaps your taxable estate or how you're going to transfer your assets, the attorney can take that into account and factor in what changes are needed, if any, to updating your trust.
Some clients inherit outdated documents from parents or older relatives. What are the signs that a plan is too old to rely on?
I have seen some very old plans on very old paper. It does happen, and you do need to look out for keeping things up to date. So that's where I would encourage kids to talk to their parents. And if they do have a trust or know that their parents have set something up for them, ensure that it's up to date, it's accurate, you're not getting old pages. What you want to do is ensure that your parents or whoever have set up this trust, while they have their capacity, can make the changes necessary. So if there's changes to the law or changes to their family, they're up to date with those changes and they have the ability to make the changes while they're alive. Otherwise, you're getting very old documents and perhaps they're still relevant. Perhaps they still cover exactly what that trustor wanted 20, 30 years ago. It's still a valid trust. And the court, acknowledging that it's an agreement buying between the same person, which they're contractually allowed to make, they will still follow the terms of that trust to the best they can. If things have been outdated or changed in the 30 or 40 years, perhaps subsequent to signing the trust, they will take that into account, but they can administer that trust faithfully, trying to find the trustor, grantor, settler's exact wishes and following those through.
When you meet with someone for a plan review, what do you usually look for first?
So when I'm going through a trust from a client, if it's mine or whether it's been brought from someone else, I want to make sure A, it's reflective of their wishes. So it's up to date with the right family, it has the right distributions, it has perhaps the trustees and the subsequent trustees that they trust to administer this trust when they're gone. But making sure their designations are correct, I ensure they have powers of attorney, advanced healthcare directives, and HIPAA releases so that if something does happen to them while they're alive and perhaps they just lack capacity, that there is someone who can step up and make real life decisions for them. But I want to look at those documents and keep them up to date. So if they're very old, make an amendment or a restatement that captures any changes in the law, that captures any changes in their family structure or their business entities or how perhaps a divorce or a separation. These are all things that impact how the trust probably will work and go to the beneficiaries when you pass. So we'll make sure those are all up to date, that you have your wishes properly recorded, reflected, the beneficiaries are accurate, and the conditions you have on that money, if any, are still in place. So things like sobriety or educational standards, ensuring that they get a certain portion at 25, 30, 35. You can really get creative and making sure that that person who you want to receive your money is set up properly to receive that. And if you need to make adjustments to how they receive that, you can do so as well.
How often do you recommend families schedule a review if nothing major has happened?
So that if nothing major has happened, it's a very different story. But I say either way, just call your attorney every 3 to 5 years. I put a letter in my binders for clients, just giving them that reminder that they should keep things up to date. Reach out to the attorney, see if there's any changes that significantly require the need to amend the trust or look at the tax savings and the tax benefits that we can pass on to the beneficiaries. That's an assessment we can do as the laws change. So if your family structure doesn't change, I would say at least touch base with an attorney or whoever helped you with the trust every 3 to 5 years. Give them a call, check in, just say, hey, anything like the big beautiful bill that's going to impact how we've tax strategized our estate, and you can make that assessment. And if the change is needed, you can do something as simple as an amendment or a restatement.
What tends to happen when people wait too long to update their plan? Are there common problems that you see when a family brings in documents that are 10 or 15 years old?
Yeah, so unfortunately, when things are too old and the people that have set the trust up have passed, it's too late. That trust has become irrevocable. But if the settlers are still alive and they're still around, they're in the office, I encourage them, if they don't already have them, to get powers of attorney, advanced healthcare directives, and HIPAA releases in place so their agents have the authority. God forbid something happens to them and they need someone to sign their name on taxes, that ability is still present. But the documents need to be reviewed with the person who set them up. And if that person is not available, we have to look at how to then administer that trust because perhaps at that point it's then irrevocable.
Hmm. For someone who already has a trust, does updating it mean rewriting everything, or can parts of it be amended?
So when looking at a trust, you can either amend it. If it's a simple change, we typically suggest the client do a simple amendment, and that's as easy as coming into the office or giving a call to the attorney, stating what you want changed in the trust. Perhaps they'll review it for other updates or changes in the law, needed adjustments. But you can do a simple, small amendment, and you can have as many of these as you want, and these will continue to track the original copy of the trust. If you have significant changes, the attorney may say either do one of two things. If you don't have a lot of assets in the trust, you can create a new trust, or you can restate the trust. And that's where you can give the original trust document a full, clean start. You kind of redraft the trust with the same structure, the same name of the trust, but with new bones inside of it. And with that, you have the changes addressed from that settler so that if it's not in the original trust, it wasn't originally planned, it can be accounted for on a go-forward basis.
Finally, for anyone listening who hasn't looked at their plan in years, what's one simple step they can take this week to ensure that their documents still protect their family the way they intended?
So, great question. And I would walk away from this episode going back to the binder and just looking at the designations. Are the people, the person who set up the trust, put in place, still the people they want administering the trust or receiving the fruit of their estate? It's a good idea just to casually look at this. You're going to have these things in the back of your mind anyway. So while you're going to lunches and visiting families, it may pop in your mind, oh, this person's no longer around, or I need to change something small. You come back home and you can do that via a simple amendment. But otherwise, reviewing your powers of attorney, advanced healthcare directives, your wills, and your trusts to make sure all your assets are in there. And if they're not, that the account or 401k or life insurance names the trust as a subsequent beneficiary, and that everything is otherwise in order. Your designations, the amounts you want to give to your beneficiaries, nothing there has changed. Provided it hasn't, you can keep what you have and know that everything's in place, and just check back again in a few years.
Well, thank you so much for all of the information today. And thank you for listening to Protecting Your Legacy with Estate Planning. To schedule a review or learn how you can keep your plan current, visit stonewoodlaw.com. Please like, leave a review, and share this episode with someone who might need it. Thanks again, Adam.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.